Hi small business owners, it's Western Singh from Western Law Firm. Today I want to continue the talk about the remaining methods of how to hold title for a real property. Previously we have seen tenants in common, and now we will be looking at joint tenancy, community property, and community property with right of survivorship. So let's see joint tenancy. Joint tenancy and also all other methods have one thing in common, that you own or you have access to the whole property, regardless of how much share of ownership you have. Even if you are, suppose in joint tenancy, usually it's equal share, 50% owner. In community property, it's also similar, 50% owner. That doesn't mean you own like this much section of the property 50% and the rest of your co-owner can just kick you out from the rest of the property. It doesn't work like that. So regardless of the method, so you should have complete access to property. And I know sometimes the co-owner fight about that, but legally you should have complete access to the property regardless if you have any kind of agreement on the side. So that's the common thing. So what are the main differences in tenancy in common and joint tenancy and other tenancies? So in tenancy in common, in joint tenancy, one of the biggest benefit you have is the right of survivorship. Right of survivorship means if your co-owner dies, then you will get the share of your co-owner automatically without going through a very extensive probate process. That's one of the biggest benefit. And that's also been seen as one of the disadvantage, because sometimes people take property in joint tenancy and usually they don't see their grant deeds for a while. Their co-owner dies and now the deceased co-owner family is looking at this property, and unfortunately they just came to know it was in joint tenancy and they don't have any right on that property. So that's one of the disadvantage you have, and so you have to be careful in what kind of way you are holding title. It's really important and will decide if when you die you have the access or the ownership of the property or not, or your survivors will get something or not. So that's one of the main benefit of the joint tenancy. However, to establish joint tenancy, you need to have an express intent of having a joint tenancy. So whoever is the grantor of this real estate, whenever he's providing a grant deed, he needs to mention that this property or these people hold title in joint tenancy, so this importance of right of survivorship, people can see that and they know and understand the consequence of it. And also there is other requirement that you should own, that the co-owners who are going to be in a joint tenancy need to own this real estate under one document and in one conveyance. What that means, that these co-owner need to have their name on the grant deed mentioning it's a joint tenancy, and they have to get this ownership at the same time. So that's one of the requirements which is also needed for joint tenancy. Okay, let's see the next, community property. So community property, it's a concept which is just applied to married couples, and California is a community property state. So the concept is that whenever you get married and whatever you purchase any real property after that becomes a community property, unless and until your spouse, or you have an agreement with your spouse, or your spouse transmute it or waive it as your separate property. Unless and until that happens in writing, that property is a community property, regardless of that who spent the money. And sometime it happens you are living separately with your spouse and now you own this real property, and now you're thinking, okay, only my name is on the title, and and I am the owner, but unfortunately you are not. And even I think if you are using an escrow company, probably they will ask you, are you married? That's one of their main question, because they are giving you title insurance, and if anything goes wrong, so they are liable for that, and people will use their title insurance to fight any lawsuits or to have any other legal issues to deal with. And it's get really important when you're selling your property, because when you're selling your property, and if it's a community property, then you need the consent of the other spouse. And this situation comes in when you are living separately and one spouse is selling the interest, and suppose that spouse only has the title on their name, but still it's a community property, and you cannot just sell it by just only with your signature. And probably if you're using escrow company, I think definitely say they will ask you many questions. And are you married, single? If you're married, then yeah, they need their signature unless and until you're divorced. So the situation comes in because they have to fight your lawsuit and pay for that. So it's really important to look even for the buyers. Is your seller married, and what's going on with their title? Because sometimes people just get the property as a grant deed without going through escrow. So even they don't have any people to have that kind of due diligence in their mind. And later they know that there is a spouse who is living separately, and or even the husband didn't mention her about any property, and the spouse just comes in and the spouse is just protesting that I have not even signed the grant deed and you should not get the title, and there are rules that she can challenge the sale, and now our buyer is in trouble, have to spend legal money and have to take a lot of headaches to just clear up the title. Okay, let's move forward for our next method, which is community property with right of survivorship. So basically it's again community property, so it's related to married couples and also registered domestic partners. So it's basically getting the benefit of community property and also getting the benefit of right of survivorship as with the joint tenancy. So what are the main benefits? So with only having community property, the spouses can will their 50% to any other person. However, in community property with right of survivorship, the main benefit is not to go through probate action to get this interest. Whenever one spouse dies, other spouse automatically get title. However, one spouse cannot will away the property to some other person. It just acts like joint tenancy. Even in joint tenancy, it's similar, that you cannot will away your interest once you die to some other person. Because even if you do that, that would not be an effective thing. So it's similar to the community property with right of survivorship. However, with community property with right of survivorship, you need that the grantee also signs the grant deed or any document which is conveying the ownership of this property to these co-owners. So that's one of the main thing you have to keep in mind. If you want that you should get this real property from your spouse, so these are basic requirements, that you need to have community property with right to survivorship. You cannot have any kind of will associated with that, or you need to have a grant deed which is signed by a grantee. And there are also other tax benefits. Probably I think a good person would be your accountant or your CPA to talk about. So I will only talk about the legal issues or basic legal framework under which you can own title. So again, if you have any legal issues, so you should go to a legal professional. Just don't watch this video and try to resolve your issues. And always work hard, work efficiently. And if you have legal worries, we are here to listen that and try to help in just trying to achieve your business growth. Thank you and see you in next video.